Hello everyone, welcome to Court with Krissy. Today's arraignment features co-defendants who made the drive up north to deliver drugs, and it resulted in a death. Both co-defendants do not like the bond that the magistrate sets because they got kids. I hope you do like the bond the magistrate sets, and if you do, be sure to hit the like button. Court with Krissy is now in session.
Oh, thank you. Good afternoon. May I have your name, please?
Demario Devlin Lindsay. Good afternoon.
Good afternoon, Mr. Lindsay. We are on the record in case number 24-1746FY. You're appearing for arraignment purposes this afternoon. You're appearing with Ms. Conlon, the defense attorney available through the Indigent Defense Counsel, here to assist you. Ms. Conlon, did you have opportunity to review the allegations on the complaint, nature of the offense, and the possible maximum penalties with Mr. Lindsay?
I did, Your Honor. We would waive a reading. Mr. Lindsay stands mute and is requesting that the court assign counsel to represent him. He did previously have Mr. Johnson on some charges that were dismissed.
Thank you. So, Mr. Lindsay, in order to complete a petition for a court-appointed attorney, I need to place you under oath and ask you some questions. Would you please raise your right hand? And you swear that the information you're about to give me will be the truth to the best of your knowledge?
But with the truth.
Thank you, and you're welcome to lower your hand. Mr. Lindsay, what's your phone number? What is your mailing address?
Saginaw, Michigan 48601.
Do you have an email address?
No, ma'am, not at the moment.
At the address and you're renting, purchasing the home, or living with others?
Living with others.
Are you working?
I get disability.
Do you receive any other sort of assistance or income?
Not at this point in time, ma'am.
Do you own a vehicle?
Not at this point in time, ma'am.
And do you have any money in a checking account, savings account, any cash on hand, or any digital currency?
No, ma'am.
I will appoint an attorney for you. I'm going to remind you that you have the right to remain silent. Anything that you say, orally or in writing, can be used against you. You have the right to have an attorney present during any questioning. If you could not afford an attorney, the court would appoint one at public expense. You have the right to have the attorney present during all subsequent court proceedings. You have the right to a preliminary examination. In this case, it would be scheduled for May 6th, 11 a.m. with Judge Stepka. Also, on April 30th, you would have a probable cause conference. Ms. Conlon, is there information that you'd like me to know regarding bond?
Mr. Lindsay does reside in Saginaw. He's been living in Saginaw his whole life. As he told you, he does receive SSI. His kids are living with him now. And he wanted the court to know that he has been at all previous court appearances in the prior case that was dismissed. So he is requesting perhaps a PR bond or low 10% bond. He certainly would abide by a GPS tether if the court was to see fit to impose that condition.
We also have Ms. Roberts from the prosecutor's office. Ms. Roberts, is there information that you would like me to know regarding bond?
Just briefly, Your Honor, thank you. In regards at least to the case that is being referenced was dismissed, that was dismissed, but it was recharged under this complaint. So those charges haven't necessarily exactly gone away. My concern is this is a defendant who has no ties to the area. He's got previous controlled substance crimes on his criminal history. And further, this is a life offense. He's a habitual offender fourth. So given that, I don't think a 10% or a PR bond is appropriate at all. I would ask that the court issue a high cash bond on this one. And again, if the court is inclined to do a bond, I would ask for the GPS tether.
That would be cool. I got kids. Tether.
So Mr. Lindsay, I believe the bond that was previously set was an appropriate bond in that case, and those charges are sort of recharged in this case. So I am going to set your bond in the amount of a $100,000 cash or surety bond. Conditions on the bond and the reasons for that are that you have no ties to this area. It is a life offense. The allegations on the complaint in this case, the known risk to public safety, and your history of prior drug-related convictions. Conditions on the bond are that you may not use nor possess any alcohol, any illegal substance, any controlled substance, including marijuana, any mind or mood-altering substances, or any non-prescribed medication. You'll provide a list of your current prescriptions to the district court clerk. You will submit to discretionary PBTs whenever requested by a police officer or any court personnel, so you may not refuse. You will have an immediate urine screen and 4 times per month urine screens hereafter. You may not use nor possess any drug paraphernalia. You may not have contact with co-defendants, Lucretia Stanford and or Emily Helm. You'll have no threatening, intimidating, harassing, or violent behavior towards any person. You may not use nor possess any weapons or any ammunition. You'll be respectful of all court employees and care providers during the course of your case. You would be supervised by Community Corrections Pretrial Services throughout the pendency of the case. You will be required to have a GPS tether, and Pretrial Services would be supervising your GPS tether parameters.
Yes, ma'am.
Ms. Conlon, Mr. Lindsay has his hand up. Would you like to talk?
Well, I don't know whether he's got a question for you or for me, Your Honor.
Mr. Lindsay?
Yes, ma'am. I see that I was just held about this with Ms. Roberts about my previous case from 10 years ago or whatever I did time for. My last indicating my sentence was me going to see my kids. I did time for. I was last incarcerated and I did time for everything I've been did in my past. I understand the case is serious and stuff like that, but I had children I need to take to school and see stuff, and the bond is outstanding high as the last time when I get disability, like really with no support. And I was just trying to get the bond reduced because, or just let me on anchor monitor if you don't believe that I will be showing up, because T. Johnson was my last attorney and I came to every court. I even had meetings with him. There's no reason for me to run. I didn't even do nothing on this case. I didn't have a cop and everything to take. I was taking at the top.
Hold on. You don't want to talk about anything with regard to this case.
Okay.
With the facts of the case. With regard to the bond, again, your criminal history is what it is. You don't have any ties to this area. The allegations in this complaint, the seriousness of those allegations, for those reasons, in addition to the fourth offender habitual, I believe that you pose a risk for failing to appear. I believe you pose a risk for public safety. And for those reasons, the bond will be as I just ordered. And so for right now, then, sir, you are all set.
Yes, ma'am. Yes, ma'am.
Thank you.
You done here?
Yes, sir.
Thank you so much.
Good afternoon. Are you Lucretia Stanford?
Yes, I am.
We are on the record in case number 24-1748FY, and you're appearing for arraignment purposes this afternoon. You're appearing with Ms. Claxton, the defense attorney available through the Indigent Defense Council, here to assist you. Ms. Claxton, did you have opportunity to review the allegations on the complaint, the nature of the offense, and possible maximum penalties with Ms. Stanford?
I did. We'll waive a formal reading. She'll be requesting court-appointed counsel.
So in order to complete a petition for an assigned attorney, I need to place you under oath and ask you some questions. Would you please raise your right hand? And you swear that the information you're about to give me will be the truth to the best of your knowledge?
Yes.
Thank you, and you're welcome to lower your hand. Ms. Stanford, what is your phone number? What is your mailing address?
It's in Saginaw, Michigan, 48602.
Do you have an email address?
Yes.
At the address on, are you renting, purchasing the home, or living with others?
I'm renting.
Are you working?
Yes, but I'm on medical relief from my hand.
Are you receiving any sort of income or assistance?
No, my son gets disability every month. 9/14, every first of the month.
Do you own a vehicle?
No.
Do you have any money in a checking account or savings account? Any cash on hand?
No.
So we'll allow an attorney to be assigned. The court would grant that attorney. I'm going to remind you that you have the right to remain silent. Anything that you say orally or in writing can be used against you. You have the right to have an attorney present during any questioning, and if you could not afford an attorney, the court would appoint one at public expense. You have the right to have the attorney present during all subsequent court proceedings. You have the right to a preliminary examination. In this case, it would be scheduled for May 6th at 11 a.m. with Judge Stepka. Also, on April 30th at 2 p.m., you would have a probable cause conference. Ms. Roberts is here from the prosecutor's office, and Ms. Claxton. Ma'am, do you have any questions, Ms. Claxton, regarding the bond that has been set in this case?
We did. Miss Stanford was curious if the court would consider reducing the bond amount. I certainly recognize that these are charges that are serious in nature. She wanted the court to consider that she does have children at home who she needs to take care of. She doesn't have anyone else to take care of them. She was working prior to being injured in her car accident. And she also takes care of her disabled sister. She would be willing to wear a tether, although I do know on the praxis, it states that there's no failure to appear history. So we ask that the court take that into consideration and consider reducing the bond at this time.
Thank you. Ms. Roberts?
Your Honor, at this point, I'd be asking the court to increase the bond to 100,000 cash or surety, the same bond that was set for the co-defendant here. Again, this is a life offense case. There was a death here. So the charges are certainly serious in and of themselves. The defendant doesn't have any ties to this area. And the court ROA shows that she called the court back on the 27th of March, knowing about the warrant. She was advised to turn herself in and didn't do so. So law enforcement had to get the fugitive team involved to finally get her picked up. So I do have a concern with that. Also, given the fact that it's a life offense, there is a risk for non-appearance here. So I would ask that the court increase the bond to the same amount as the co-defendant at that 100,000 cash or surety. And again, if the court's going to do that, then impose a tether on that.
No, that's not true. That's not fucking true.
Hold on. I believe that the co-defendant in this case has a significant or more significant criminal history than Ms. Stanford. So I think that probably was part of the consideration when the bond was set over the weekend. The court is very concerned about the allegations in this complaint, the nature of the offense, and possible maximum penalties, absolutely. It is of interest as well that the defendant called the court, knew about the outstanding warrant, and failed to turn herself in after having been told that she should have done that. So for right now, I am going to increase the bond. It will be a $75,000 cash or surety bond with all of the same terms and conditions. Again, that's no ties to the area, nature of the offense, knowing that there was an outstanding warrant, not turning herself in.
But and that is not true.
So the bond.
So I just supposed to set up
cash or surety. And for right now, then, ma'am, you are all set.
When do I go back to court?
Your preliminary examination is May 6th, 11 a.m. with Judge Stepka. Your probable cause conference is April 30th, and you will hear from your attorney by the 1st of next week.
Okay, so when you say 75,000 cash surety, what do that mean? So it's no 10%, no nothing.
Correct. It's a cash or surety bond.
So no, nothing. I can't nothing. Like I can't do nothing but sitting here. Basically, is what y'all telling me.
The bond is what it is, and you are all set, ma'am.